Part 1. Thinking about studying law. 1. What is law? Dear Alex, thanks for your email. Your question, why should I study law at university, is a pretty big one and deserves a letter rather than just a quick emailed response. For what it's worth, my quick answer would be, people should do a law degree because studying law is interesting, important, and educational. That doesn't necessarily mean that you should do a law degree. Law isn't for everyone. But as a subject for study, I think it's tough to find another that is as fascinating, as significant, and as transformative as law is. So that's the quick answer. But it's going to take me 2 letters to give you the long version. To understand what is so great about studying law, you first need to understand a bit about what law is. That's what I will talk about in this letter. I'll then send you a follow-up letter explaining why studying law at university is something you should give serious consideration to. Law as a conversation. The question of, what is law, is one that continues to vex philosophers. But we might be able to make the concept of law more understandable through the following analogy. Suppose that you and I and a whole bunch of other people decide that we are going to go on holiday together. We all like each other, and we like spending time with each other, and a holiday is a great opportunity to do more of that. So we're going on holiday, but we still have to decide where to go, when to go, where to stay, what to do, how we are going to get there, how much everyone is going to contribute to the cost of the holiday, who is going to be in charge of what. Loads of things. To work out the answers to these questions, we need to talk to each other. There are some issues that all of us may have to talk about together, such as where we are going to go and when. There are other issues, such as transportation and accommodation, that we might be able to delegate to a few members of our party, and they will work those issues out together and report back to us. But however the various issues arising out of our plan to go on holiday are resolved, resolving them will require lots and lots of conversations. What I want to suggest is that we can draw an analogy between the notion of law and the process of talking to each other in order to decide on the details of the holiday we are all going to go on. Instead of talking to each other to determine what sort of holiday we should go on, our lawmakers talk to each other to determine what sort of society we should live in. So when we say, what does the law say on such and such an issue? We are really asking, where are our lawmakers at the moment in their conversation about what sort of society we should live in? Have they decided this issue already? If they have, what did they decide? And is there any possibility of this issue being reopened? If they haven't, then what does the state of conversation indicate at the moment about how our lawmakers might resolve this issue? The conversation is ongoing and intergenerational. The fact that a previous generation of lawmakers may have taken a particular position on what sort of society we should live in does not mean that future generations cannot take a different position, thereby bringing about a change in the law. However, the views of previous generations of lawmakers do not die with the lawmakers. The record of those views lives on and has the potential to influence the views of the current generation. So great lawmakers of the past, such as Sir Edward Coke 1552 1634, Lord Mansfield 1705 1793, Lord Shaftesbury 1801 1885, and Lord Denning 1899 1999 continue to have a voice in the conversations that go on today among our lawmakers as to what sort of society we should live in. Those conversations are conducted among and between 2 classes of lawmaker: judges and legislators. Judges decide concrete cases, telling the parties to each case what the law says in that particular case. Legislators lay down general rules in the form of statutory provisions, both for people's guidance as to how they should behave, and in order to empower people to act in socially productive ways. Both judges and legislators are engaged in determining what sort of society we should live in, and in performing their functions, each give effect to visions of what sort of society we should live in. Law that emerges from the way judges decide concrete cases is known as common law. Law that is laid down by legislators is known as statute law. The ultimate power to decide what sort of society we should live in rests with the legislators. In deciding cases, The judges must give effect to any relevant legislative provisions that have been validly laid down by the legislators. Judges are subject to a further constraint that legislators are not. In deciding a case, a judge is required to give effect, not to his or her own personal vision of what sort of society we should live in, but to the vision that seems to be supported by the way the conversation among lawmakers on this issue has evolved so far. For example, in R on the application of Nicholson v. Ministry of Justice 2012, a man who was completely paralyzed and wished no longer to live sought a declaration from the courts that it would be lawful for a doctor to kill him. The judges who decided the case may have personally thought that we should live in a society where this sort of thing is allowed to be done. However, there was absolutely no support for the idea that we should live in a society that practices euthanasia, either in statutory provisions created by legislators or cases previously decided by the judges. So the idea that euthanasia is acceptable is not one that had so far found any support in the evolving conversation between lawmakers as to what sort of society we should live in. Given this, the court in Nicholson had no option but to turn down the application, ruling that it could not hold that euthanasia was lawful until legislation had been passed making it lawful. The requirement that judges not give effect to their own personal views as to what sort of society we should live in, but rather the emerging consensus among lawmakers on this issue, is a salutary one, however frustrating a particular judge, for example, one who believes strongly in the acceptability of euthanasia, might find it. The question of what sort of society we should live in is a very large and difficult one, and no one judge, or indeed any human being, can claim a monopoly of wisdom on this subject. Given this, a wise judge will listen with respect to the views of other lawmakers, both past and present, on the issue of what sort of society we should live in, and will give greater weight to those views than his own, possibly mistaken, convictions on this issue. Of course, there are some judges, I could name a few, who are determined to give effect to their own convictions, come what may, but there exist procedures for marginalizing them. Their judgments can be overturned on appeal, and they tend not to get promoted to the higher courts, where they can have more influence on the direction of the conversation among lawmakers as to what sort of society we should live in. A concrete example. Let me now give you an example to make clearer the idea I am advancing here of seeing law as an ongoing conversation that is aimed at determining what sort of society we should live in. In the Belmarsh case, a v. Secretary of State for Home Department 2004, the issue was whether the government was entitled to detain indefinitely non-nationals whom it suspected of being involved in terrorism. The non-nationals were detained in Belmarsh prison, so that's why the case is referred to as the Belmarsh case for short. Part of what makes the Belmarsh case fascinating is that so many different, though not necessarily incompatible, views as to what sort of society we should live in were relevant to deciding the case. All of these views have found their place in the ongoing conversation among our lawmakers as to what sort of society we should live in. In deciding the Belmarsh case, the House of Lords had to determine which view should take precedence. 1. The rule of law. There is, first, the view that we should live in a society that places strict controls on how government power is exercised, so as to ensure that it is not exercised tyrannically or arbitrarily. This view expressed by the ideal that we should be governed by law and not by men. In other words, that we should live under the rule of law and not be ruled by arbitrary government fiat is wonderfully expressed in both the arguments and judgment in the case of Entick v. Carrington, which was decided way back in 1765. In that case, Entick sued Carrington and 3 others for trespassing on his land. They had gone into his house and searched it for papers, in pursuance of a warrant issued by a Secretary of State that purported to authorize them to make searches to find out who was publishing very seditious papers entitled The Monitor, or British Freeholder. Entick's barrister argued, a power to issue such a warrant as this is contrary to the genius of the law of England, and even if they had found what they searched for, they could not have justified under it. The verdict says such warrants have been granted by Secretaries of State ever since the Revolution. If they have, it is high time to put an end to them. For if they are held to be legal, the liberty of this country is at an end. It is the publishing of a libel which is the crime, and not the having it locked up in a private drawer in a man's study. But if having it in one's custody was the crime, no power can lawfully break into a man's house and study to search for evidence against him. This would be worse than the Spanish Inquisition, for ransacking a man's secret drawers and boxes to come at evidence against him is like racking his body to come at his secret thoughts. The warrant is to seize all the plaintiff's books and papers without exception, and carry them before Lord Halifax. What? Has a Secretary of State a right to see all a man's private letters of correspondence, family concerns, trade and business? This would be monstrous indeed. And if it were lawful, no man could endure to live in this country. The Lord Chief Justice, Lord Camden, found in favor of antic. The great end, for which men entered into society, was to secure their property. That right is preserved sacred and incommunicable in all instances, where it has not been taken away or abridged by some public law for the good of the whole. By the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action. If he admits the fact, he is bound to show by way of justification that some positive law has empowered or excused him. The justification is submitted to the judges, who are to look into the books. And if such a justification can be maintained by the text of the statute law, or by the principles of common law, if no excuse can be found or produced, the silence of the books is an authority against the defendant, and the plaintiff must have judgment. According to this reasoning, it is now incumbent upon the defendants to show the law by which this seizure is warranted. If that cannot be done, it is a trespass. Papers are the owner's goods and chattels. They are his dearest property, and are so far from enduring a seizure that they will hardly bear an inspection. Where is the written law that gives any magistrate such a power? I can safely answer, there is none. And therefore it is too much for us, without such authority, to pronounce a practice legal, which would be subversive of all the comforts of society. On this view, any government power to detain people indefinitely on suspicion of being involved in terrorist plots is legally suspect, as it places too much power in the hands of the government to act oppressively and arbitrarily. 2. Necessity. On the other hand, there is a view that we should live in a society where the government is empowered to do what is necessary to ensure the safety and security of the populace. This view, expressed by the Latin tag salus, populi suprema lex est, the safety of the people is the supreme law, actually finds some support at the end of Lord Camden's judgment in Intic v. Carrington. One word more for ourselves. We are no advocates for libels. All governments must set their faces against them, and whenever they come before us and a jury, we shall set our faces against them. And if juries do not prevent them, they may prove fatal to liberty, destroy government, and introduce anarchy. But tyranny is better than anarchy, and the worst government better than none at all. The view that in an emergency, the government should be empowered to act in ways that would ordinarily be regarded as oppressive and tyrannical, in order to secure public safety, underlies the Civil Contingencies Act 2004, which purports to allow the government in an emergency defined as an event or situation which threatens serious damage either to human welfare in, or to the environment of, a place in the United Kingdom, to make emergency regulations, to make provision for the purpose of preventing, controlling, or mitigating an aspect or effect of the emergency when there is an urgent need to do so. This view also underlay the decision of the House of Lords in Liversidge v. Anderson 1944, holding that where someone was detained under wartime regulations allowing the Home Secretary to order the internment of someone whom he had reasonable cause to believe was of hostile origin or associations, the courts would not inquire into whether there was reasonable cause to believe the detainee was hostile. It would be enough that the Home Secretary said there was reasonable cause to believe this. The appellant's counsel truly say that the liberty of the subject is involved. They refer in emphatic terms to Magna Carta and the Bill of Rights, and they contend that legislation dealing with the liberty of the subject must be construed, if possible, in favor of the subject and against the crown. I hold that the suggested rule has no relevance in dealing with an executive measure by way of preventing a public danger. So, on this view, the ordinary requirements of the rule of law, which suggest that the exercise of government powers should be strictly controlled, should be relaxed where the public safety is at stake. On this view, then, giving the government power to detain people indefinitely when they are suspected of involvement in terrorism might not be so objectionable. 3. Democracy. A third view that was of crucial importance to the outcome of the Belmarsh case was the view that in our society difficult questions of how to balance the need for security against the need to respect people's liberties should be decided through democratic institutions that can fairly reflect the desires of the majority as to where that balance should be struck. This view underlies the doctrine of parliamentary sovereignty, according to which the courts are not allowed to set aside or refuse to give effect to an act of Parliament. Note that consistently with the theme of this letter, Parliament literally means talking shop. The doctrine of parliamentary sovereignty is felt to be so important that when Parliament passed the Human Rights Act 1998 and committed the UK to being a society in which the state observes people's human rights, as set out in the European Convention on Human Rights, even then, Parliament took care to provide in Section 4 of the Act that the courts would still have to give effect to an Act of Parliament which the courts thought was inconsistent with the European Convention on Human Rights. All they could do in such a case was issue a declaration of incompatibility and leave it up to Parliament to decide whether or not to amend the offending legislation, and if so, how. The relevance of this third view to the outcome of the Belmarsh case is that Parliament had legislated to authorize the detention of the non-nationals whose detention had given rise to the litigation in Belmarsh. Under the Immigration Act 1971, the Home Secretary had a power to detain a non-national in custody while he was awaiting deportation. So a non-national who was suspected of being involved in terrorism could be deported from the UK and detained in custody under the 1971 Act while awaiting deportation. But many non-nationals who were suspected of being involved in terrorism could not be deported from the UK, as there was a real fear that they would be tortured in the countries to which they would be deported. Such non-nationals could not be detained while awaiting deportation under the 1971 Act because deportation was not a prospect for them. Section 23 of the Anti-Terrorism, Crime and Security Act 2001 dealt with this problem by providing that a non-deportable non-national who was a suspected international terrorist could still be detained in custody while awaiting deportation under the Immigration Act 1971, even though in practice he or she could never be deported. The effective result of this provision was to allow the government to detain indefinitely in custody a non-national who was a suspected international terrorist, but who could not be deported from the UK. In creating this power, Parliament made it clear that it thought the need to ensure the security of the British people by detaining in custody non-nationals who were suspected of being involved in terrorism outweighed any concerns about depriving such non-nationals of their liberty. Given this, how could the courts justify taking a different view? 4. Discrimination. But there is, fourthly, a view that we should live in a society where the government and other important institutions are not allowed to discriminate against people for morally arbitrary reasons. This view has only comparatively recently found its way into the conversation among our lawmakers about what sort of society we should live in. It finds expression in Lord Denning MR's great judgment in Nagel v. Failed in 1966, where the Court of Appeal held that a horse owner could sue the Jockey Club for denying her a license to act as a trainer merely because she was a woman. The common law of England has for centuries recognized that a man has a right to work at his trade or profession without being unjustly excluded from it. He is not to be shut out from it at the whim of those having the governance of it. If they make a rule which enables them to reject his application arbitrarily or capriciously, not reasonably, that rule is bad. It is against public policy. The courts will not give effect to it. Such was held in the 17th century in the celebrated case of the tailors of Ipswich 1614, where they had a rule that no person was to be allowed to exercise the trade of a tailor in Ipswich unless he was admitted by them to be a sufficient workman. Lord Coke CJ held that the rule was bad, because it was against the liberty and freedom of the subject. I have said before, and I repeat it now, that a man's right to work at his trade or profession is just as important to him as, perhaps more important than, his rights of property. Just as the courts will intervene to protect his rights of property, they will also intervene to protect his right to work. When an association, who have the governance of a trade, take it upon themselves to license persons to take part in it, then it is at least arguable that they are not at liberty to withdraw a man's license, and thus put him out of business without hearing him. Nor can they refuse a man a license, and thus prevent him from carrying on his business in their uncontrolled discretion, if they reject him arbitrarily or capriciously. There is ground for thinking that the courts can intervene. Note how Lord Coke can be seen here as talking to Lord Denning across a 300-year interval to shape Lord Denning's vision of what sort of society we should live in. Lord Denning's theme was taken up by Parliament in passing the Equal Pay Act 1970, requiring employers to pay their employees the same amount for work of equal value, regardless of their sex. The Sex Discrimination Act 1975, requiring employers, education providers, shops, and landlords not to discriminate unjustifiably between people on grounds of their sex. And the Race Relations Act 1976, banning discrimination on grounds of race by employers, education providers, shops, and landlords. The view that we should live in a society where the government and other important social institutions do not discriminate against people on morally arbitrary grounds has most recently been given expression in the Equality Act 2010, which brings together many earlier anti-discrimination provisions. It also underlies Article 14 of the European Convention on Human Rights, which provides that the enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any ground, such as sex, race, color, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth, or other status. The relevance of this view to the Belmarsh case was that the power to detain suspected international terrorists that was under scrutiny in Belmarsh only applied to non-nationals. That is, people who were not UK citizens. So a UK citizen could not be detained indefinitely under S. 23 of the Anti-Terrorism, Crime and Security Act 2001, even if he was also a suspected international terrorist. One can understand why Parliament ended up in this position. On one view, Parliament may have thought that it was simply plugging a loophole in the original Immigration Act 1971, under which the government could only detain suspected terrorists who it wanted to deport if deportation was a practical option. As the power to deport only applied to non-nationals, Parliament's fix of the Immigration Act 1971 also only applied to non-nationals. On another more cynical view, it may be that Parliament intended that S. 23 of the 23 Act should operate in a discriminatory fashion. Parliament may have thought that the people in the UK would not put up with the indefinite detention of a UK citizen on mere suspicion of being a terrorist, but might be relatively indifferent to someone who was not a UK citizen suffering a similar fate. Either way, the effect of ESTA 23 was that the power to detain suspected terrorists indefinitely in custody applied in an unacceptably discriminatory fashion. It worked against non-nationals, but not against UK citizens when there might have been no morally significant difference between them. The outcome of the case. The doctrine of parliamentary sovereignty made it inevitable that the House of Lords would have to rule that the indefinite detention of non-nationals who were suspected international terrorists was lawful under S. 23 of the 2 Act. However, the House of Lords also made it very clear that the existence of such a power was repugnant to their vision of what sort of society we should live in, and declared that the power to detain indefinitely non-nationals who were suspected of involvement in terrorism was incompatible with the European Convention on Human Rights. Lord Hoffman gave the most outspoken judgment. This is one of the most important cases which the House has had to decide in recent years. It calls into question the very existence of an ancient liberty of which this country has until now been very proud. Freedom from arbitrary arrest and detention. The power which the Home Secretary seeks to uphold is a power to detain people indefinitely without charge or trial. Nothing could be more antithetical to the instincts and traditions of the people of the United Kingdom. Freedom from arbitrary arrest and detention is a quintessentially British liberty, enjoyed by inhabitants of this country when most of the population of Europe could be thrown into prison at the whim of their rulers. It was incorporated into the European Convention in order to entrench the same liberty in countries which had recently been under Nazi occupation. The United Kingdom subscribed to the convention because it set out rights which British subjects enjoyed under the common law. This country, more than any other in the world, has an unbroken history of living for centuries under institutions and in accordance with values which show a recognizable continuity. A power to detain on suspicion of being involved in terrorism is not compatible with our Constitution. The real threat to the life of the nation, in the sense of a people living in accordance with its traditional laws and political values, comes not from terrorism, but from laws such as these. Though it was under no obligation to do so, Parliament listened to the House of Lords' views and repealed 23 of the 2001 Act, replacing it with a power under the Prevention of Terrorism Act 2005 to impose control orders on an individual in order to prevent or restrict involvement by that individual in terrorism-related activity. Where we are now. The Belmarsh case was just one episode in the great, centuries-long conversation between our lawmakers about what sort of society we should live in. Stepping back a bit, it might be worth giving you an overview of where we are at the moment in this conversation. Our lawmakers seem to agree at the moment that we should live in a society where persons 1. People are required to observe certain minimum standards of decent conduct in the way they treat other people, and will be able to obtain effective remedies from the courts when those minimum standards are not observed. These requirements and remedies are set out in the law of tort. 2. People who deliberately fail to observe these minimum standards may be punished by the state. The conditions under which such a person may be so punished are laid out in the criminal law. 3. People have the power to make binding promises and enter into binding agreements with other people, and effective remedies will be available from the courts when such binding promises or agreements are broken. These powers and remedies exist under the law of contract. 4. People are able to recover the value of money or other benefits that they have conferred on other people by mistake or under unacceptable pressure, or in the confident expectation of getting something in return which never came. This power to recover a benefit one has conferred on someone else exists under the law of restitution, or the law of unjust enrichment. Different people prefer different titles for this area of law. 5. The sort of education people get, or where they work, or where they live, or what goods and services they can buy, or the way they are treated by the government will not be affected by their gender, or their race, or their sexual orientation, or any other morally irrelevant characteristic. Provisions ensuring that this is the case make up anti-discrimination law. Property. 6. People are able to acquire and dispose of property, and will have effective powers to control, retain and recover such property after they have acquired it, and before they have disposed of it. The powers to acquire and dispose of property, and to control, retain, and recover it are the subject matter of the law of property, which area of law is usually split up into land law, the law of personal property or commercial law, and intellectual property law. Markets. 7. People are able to trade goods and services with each other, and are left free to determine for themselves the terms of trade, at least where they are of equal bargaining power. These powers to trade with each other and determine the terms of trade and the limits on these powers are also dealt with by the law of contract. 8. People are free to combine together to form companies, through which they can trade goods and services, sharing in the profits made by the company, while limiting their liabilities if the company is unsuccessful. These powers are dealt with by company law. 9. Traders in the marketplace are required not to conspire together to rig their prices, or to abuse a dominant position that they have acquired in the marketplace to drive out any remaining competitors. These limits are dealt with by competition law. Families. 10. People are empowered to enter into lifelong commitments of care and support to each other by marrying each other. On dissolution of the marriage, the courts will enforce those commitments by fairly redistributing the assets and future incomes of the parties to the marriage. The power to marry and the conditions for and consequences of a dissolution of a marriage are dealt with by family law. 11. Parents have special responsibilities to look after their children and powers to control what happens to their children. And non-parents are empowered to take on parental responsibilities towards children who are no longer cared for by their natural parents. Again, these aspects of social life are dealt with by family law. The state. 12. The state is empowered to define certain forms of antisocial conduct as punishable, and to punish those who engage in such forms of conduct. These forms of conduct, and the punishments applicable to those engaged in them, are laid out in the criminal law. 13. The state operates under the rule of law, which means that exercises of government power, other than the power to pass acts of parliament, are subject to strict controls to ensure that such powers are exercised rationally and in a way that is consistent with the reasons why those powers were created in the first place. Roman 2 with people's legitimate expectations as to how those powers will be exercised. Roman 3 with certain fundamentally important values, such as the need to respect people's liberties and the importance of observing due process before making decisions that have a major impact on an individual's life. These limits on the exercise of government power are dealt with by administrative law or public law. Different people use different titles for this area of law. Foreigners who have a well-founded fear of persecution in their own countries will be able to seek asylum here. The power to seek asylum in the UK is dealt with by immigration law. Parliament is free to change any aspect of 114 above. As we have seen, this is known as the doctrine of parliamentary sovereignty, and forms part of what is known as constitutional law. 2 points need to be made about this overview. First, being an overview, it is necessarily extremely superficial. The study of law involves getting a much more detailed understanding of all of these different areas of law, finding out, for example, what we are required to do for each other under the law of tort, what sort of things are capable of amounting to property, and what are not, what will happen when a marriage is dissolved, and so on. Studying law also involves getting an understanding of how tensions between these different areas of law are resolved. For example, what happens when you and I enter into a contract under which you agree that I can treat you in a way that would normally be forbidden by the law of tort? And what happens when Parliament legislates to relax the controls that the courts would normally place on the exercise of government power? Secondly, if this overview seems very familiar and, dare I say it, a little bit boring, don't worry. The law gets a lot more interesting the more you know about it. That is because it's basically describing the society you live in. Our lawmakers made it that way, making a reality of their visions of what sort of society we should live in. Things could have been different. There were plenty of alternative visions of what sort of society we should live in available to our lawmakers, which they might have gone for, with the result that we would live today in a very different kind of society. And it may be that things will be very different in future. The conversation between our lawmakers as to what sort of society we should live in may evolve in surprising directions in the next 50 years or so, with the result that our society will become unrecognizably different from the sort of society we live in at the moment. To be continued. That's enough from me for the time being. I hope you've got a good idea from this letter of what we are talking about when we talk about law, and obtained a few insights into the current state of the law in this country. If you have, you'll be in a much better position to understand my next letter, in which I'll explain why law is such a great subject to study at university. Until then, all best wishes, Nick.